Good morning, admin and adwomen. Thank you for joining the call. It is 11 sharp, and we would like to get this webinar underway. Just for those who are not in earlier, I'll request that you keep your mic off and your video on if you can, and I'm sure we'll have an amazing interaction, and there's lots for us to learn. If you can put your video on, would be happy to see your faces. Those who will join us later will have maybe moments of recapping if time allows, but we are committed to keeping within the time that has been allocated for this webinar. So, ladies and gentlemen, please allow me to officially welcome my president, as protocol would have it. President Frank Muthusi, you're very welcome to this webinar, and thanks for putting this together. Thank you, Liz, for all the hard work and for getting our speaker in. So, ladies and gentlemen, we're going to have our speaker present, and thereafter we'll have some questions. We know that many ad agencies, of which you are part of, obviously, have been to pitches, presented ideas to clients, and after a while, seen your ideas making grounds without your involvement. And we know that there is nothing new under the sun, but we would like to assume that you cannot have two people think exactly the same way, because God has created us to be unique that way. So we're here to really try and understand how we can address those matters where some of our ideas have been taken and the copyright of which has been infringed upon by clients, sometimes knowingly or unknowingly. So this is really to help us get clarity on what to do when such a thing happens. So please welcome with me Mr. Philip Kalibala Nyanja, who is going to speak to us. I'll let him do his introduction so that I don't mess his titles up. But he is well poised to give us the information that we need in order for us to protect our creative ideas, and also to get the most out of the hard work that we put in for our clients. So without any further ado, Philip, the floor is yours, and welcome.
Okay, thank you, Kamara. Like I had informed Liz during the testing that I would prefer speaking like this, and I'm hoping that I'm being heard well. Please send me a thumbs up if you're hearing me well, because I can't be able to hear myself. Yes, my name is Kalibala Nyanja Philip. I'm the acting manager for copyright in Uganda Registration Services Bureau. I think the other thing I would request for is, I think, for Liz to exit her screen so that maybe I can share mine. Is that okay? Yes. Okay, then I can go ahead and share. Now, just an introduction before I go into the discussion of my paper, is that it was important for me to know your trade, okay? To know your trade. What do you do in advertising? That background was very important for me, because then I could give a context of the legal framework. How do we protect you? Because the most important thing is if there is a third party who is going to assist you with issues to do with copyright or intellectual property, they have to know how your trade works. We have a legal framework and we have policies in reference to intellectual property. But as you recognize, intellectual property and creativity are extremely broad. So here in Uganda, because of the market and the circumstances, we've been mainly focusing on music, we've been focusing on films, and then we've been focusing on books. So you'll find that most of our laws and policies and everything that we write up is usually in reference to those aspects of practice. We have developed ourselves in knowledge in as far as music is concerned, which we call audio works, also as far as cinematography works are concerned, and also as far as books are concerned. So now we get other aspects, other people coming in the practice telling us that we also want protection. We also want to know whether we have intellectual property in certain aspects that we do. So what is most important for us, and what I'm going to task you with, I think eventually, is for me to know your trade, so that to know your trade extensively, so that I can know how the legal framework and our policies fit in. But be it as it may, I'm already convinced, like I've always been convinced from what I've read and everything, that your trade, which is advertising, really is protectable, and it's already an intellectual property. So don't worry about that. That one I know. If I give a paper and I kind of misfire, or I kind of get off, I get troubleshooting, or I misfire on a particular aspect, you will come in and correct me and maybe say that is not applicable, or that is not that you've not discussed it the way it's supposed to be discussed. Okay, can I get a thumbs up if it's still here? People, you're following me? Okay, the camera. Thank you. I was given, I think, about 40 minutes in the original plan, but since Kamara has opened me up at 11, so I will take, I'm supposed to speak almost up to 12, but I will not reach there. I will just give some aspects so that I can trigger off a Q&A, a discussion, so you can understand the subject better. Okay, so I'm not really going to take so much of the 1 hour discussing this aspect, because we usually do not have sufficient time really to discuss everything. But my objective here is to leave you at least primarily knowledgeable about this, so that I can trigger off further communication with you on this subject, and also to provoke you to come to our offices all the time to inquire about this intellectual property. So let me share my my screen, and then we can start off. Sorry, are you seeing my screen? Just a minute. You are sharing your screen, stop here. Kamara, am I sharing my screen in a way that you can see my screen? Should I need to, do I need to make some expansion on it? Let me hear. Yeah.
Click that button at the bottom just to maximize, so we see the current.
Yes, I'm trying to look for it.
It's right down in the bottom, just at the bottom right. Okay. No, the last. After the comments, there is no. Next.
Next, this one. This one.
Move to the right, the extreme right.
No. The extreme right. This one.
That one, yes, that's the one. Okay. That's the guy you need. All right. Awesome.
Okay, thank you. So we are ready to marathon. Thank you so much. Okay. You tasked me with this paper, Managing Intellectual Property in Uganda. And so my approach is I'm going to give you a context. What is intellectual property? Some of you are telling me that you've heard about intellectual property, but you really do not know what it means. And then we shall zero down to what copyright is and what your sector is. So just follow the presentation. The paper is self-explanatory, so I'm going to give you, you're going to see the slides, and then I'll come in to explain certain concepts. Okay, so who are we? We are Uganda Registration Services Bureau. That's who we are. We are the Intellectual Property Office of Uganda, and we were established under a law. So we are here legally, we are legit. And we are also the Copyright Office of Uganda. Okay, where all matters concerning copyright, we are the one-stop shop. So when you talk about copyright, when you mention copyright, then it has to be URSP. That is our logo in the extreme corner, right? This one where I've pointed. And down here is these are our physical premises as they are now. The purpose for putting them on the slide is to make people get a picture easily. When you're on this street, this is George Street. This is where we are located. Physical location, George Street. Next to YWCA, and I usually tell people behind this CPS, the Central Police Station, as we knew it in Kampala, in case these physical addresses, these notations disturb you, but this is where we are, and our accounting officer is the Registrar General. So whenever you're making any communication, I'm here under the instructions of the Registrar General, and our Registrar General is Mrs. Masek, Wisho. Some of you have seen her in the papers. So whenever you're writing any correspondence, Even after this paper, you do not write it directly to me. You write it directly to the Registrar General, and then it will trickle down because she's the accounting officer. And so we also have other assistants who are the Deputy Registrars General. So this is where we are. That is our structure. I believe some of you have passed this street and have seen it. And when you enter this structure, you come straight to the 6th floor. That is where we are. At the 6th floor, that is where our office sits. Okay, there we go. In detail, I gave it its own slide, so don't miss it. But I need to inform you that you can take, of course, I will share this. I'll share this presentation with you. Definitely, I have to. I will give it to the President or Liz. But some of you have passed by here and you've seen this structure. These are where our offices are. But later on, when we make an update, maybe in about 2 or 3 months, or before the last quarter of this year, we shall change premises. And when you change premises, these pictures shall change. But as it is now, this is where we are. And it's at the 6th floor in this building that I'm making this presentation. Okay, so we go straight into intellectual property. What is intellectual property? What do we mean when we say intellectual property? Intellectual property, I've also made a slash, the concept of creativity and innovation. Intellectual property, it is about creativity, it's about innovation, it's about coming up with something new, okay? It's about coming up with something new. If you look at this word intellectual, sorry, going back, if you look at these words intellectual and property, you can separate them. You might not have to read them as one word. You can say intellectual and property, because at the end of it all, whatever you create has to be property. It has to be property like this pen you see I'm holding. It has to be property like this phone you see I'm holding. So it becomes property eventually. That is why intellectual and property, you can separate them, but usually we read them as one word, intellectual property. And then all the rules that govern protection of property are also governing protection of intellectual property. In short, we call it IP, as you see here, and I'll keep on using the word IP, the phrase IP, for easy communication. So intellectual property is the concept of creativity and innovation. So anything that you come up with, I want you to look at your environment as it is right now where you are. Everything that you see around you was created, and that's when you have to agree with me. There is nothing so much as natural apart from yourself. You're the one who was created by God. You're God's creation, so you're intellectual property to God. But everything that you have, from the clothing that you have, and from the, I see Kamara is wearing specs, and then a nice suit, a nice blazer. All that is created, and you know that you went and purchased that. So there is someone who put an effort in creating that. That's what we call intellectual property. If it wasn't created by God, then it was created by man. And if it was created by man, then it becomes that man's property. That is their intellectual property, as we shall see going forward. So in your context, whatever you've created, I want you to hold on to that in your creative, in your advertising sector or industry. Whatever you've created, which wasn't there, it wasn't there in the beginning, I didn't know it. So you came into the picture and then you created it. That becomes intellectual. Sometimes this intellectual results into physical objects, like this phone I'm holding. This became a physical object. Like this pen you see here, this became physical. Like this, the stapler you see here, this became physical. But we also have non-physical intellectual property. Commonly in music, audio works. So you're listening to music, we want to play music in the background, but you can't carry music, you can't lift it. That is intangible, but it's also intellectual property. Okay, let's move on. So this picture kind of summarizes what I've tried to explain to you. You can see this man, and that's his head. And in the head of every man, you and me, all these, because all the environment that you see around you has been created by our intellect. So that picture shows you that all those rockets, cars, everything is coming from your mind. You can imagine the hugest ships, astronauts going to the moon, putting up those space stations. It all comes from you. It all comes from the brain. It's in the brain. So when you create it, then that becomes IP. It has come from the mind and you've created. It's about creating. Intellectual property, like I've said, it's about creating. And then some of this property can be physical. You can feel it like the phone you have in your pocket, or it can be something intangible. You can't feel it, but the property is there. Let's move on. So that in a narrative, that is what it is. Intellectual property is property that originates from the mind. And then an idea is conceived and reduced to material form. Some ideas, however, might be reduced to intangible and feelable forms. Okay. Kamara, I'm watching you as my main audience. So in case there is anything that people want, you just do that, and then I will put on my headphones to hear what they are saying. But as long as I'm doing fine, you just give me thumbs up to go, especially the audio. You have to listen to me, and then we also have to see the slides. So that is what it is, that an idea is conceived and reduced to material form. Like I've said, some ideas, however, might be reduced to intangible and feelable forms. You know, we've talked about music. We've also talked about films. Those are intangible, but still they are IP. Okay, and then we move on. So this is Albert Einstein saying the same thing. The human mind has to first construct forms independently before we can find them in things. All right. So you come up with what you people, I think you use so much of the words concept. You come up with a concept. So you dream of making a car. I want to talk about adverts here to be very close to your sector. You dream about coming up with an advert. We talk about the Bosco advert, the one of MTN. So someone sat down, and then everything first worked out in the mind, all the filming and everything. So then it was extracted from the mind for us to be able to see such a good commercial that went viral. But it all started from their mind. So it became intangible, but it became IP. So it came out in form. So we saw the characters, and then we saw everything to do with the forms and whatever we saw of that advert, and it went viral, as you can imagine. So I think the person or maybe the people. So we go on. That is the quote. So these are some of the things, and that's what I'm trying to show you, that I'm going to ingrain it in you. Everything you can see a car, you can see a toy car, you can see phones, you can see shirts, you can see shoes, you can see pencils, you can see buttons here. You can see huge inventions like ships. A ship is there, you can see mirrors. So the smallest, as long as you do not find it in a state of nature that it was created by God and it was created by man, whether a small pin, it's all that person's IP. Those people have created it and it's protected. Okay, so this is the question. So is IP only about creation and invention? So what if someone creates and invents? Okay, so what if someone creates and invents? Is it really about that? Is that where it stops? That people in Uganda, you saw a gentleman who made a car. They make cars down there in the Musa Bodde University. You see them making cars. They even drive them. But is it okay? They have IP. They have come up with something. But is it about that? No. So IP is about commercialization. Now, when you've come up with items like the phone, that is when now it feeds into the economy. Okay. Now, intellectual property and economy, they are twins. Intellectual property is not an end in itself. It's a means to one end. It has to feed into the economy. It really becomes it becomes weak and useless if you cannot have commercial value out of it. So if you're right there and you make so many adverts, you could have them there. They are on your flash list. They are very catchy and fancy, but you don't have clients. No one is buying them. They're not out there in the market. So yes, you have IP, but then it does not feed into. It does not become economically beneficial to you or to the whole value chain. The people who make it, the people you feed, the people who have put up your studios. It cannot. So IP and economy are one thing. That one you can write it. When you create intellectual property, you have to look at the economy as the final destination for your IP. So, and that's where the protection comes in, that the people who create this IP also have to be protected. You have to be protected. The system has to protect you for you to benefit from your intellectual property. Okay, so now we have up here, you've seen types of intellectual property. Now we're going to discuss types of IP. And this is where you come in. I'm going to give you explanations on this. You are people in advertising, and this is important to you. Types of IP. We have trademarks, okay? And the way we define trademarks, trademark means a sign or a mark or combination of signs or marks capable of being represented graphically and capable of distinguishing goods or services of one undertaking from those of another undertaking. In other words, you will see the pictures. Trademarks are symbols. They can be symbols. They can be words. They can be even people's faces. Kamara's face can be made into a caricature. You've seen like the KFC. And then just your outlook. If your outlook is unique, if you create a caricature of yourself and your outlook is unique, and then it gets into the market as that face belonging to you, then you can register that. That can be an IP. You can register it as a trademark. Okay. So it's about symbols, the appearance of things, and it's also about words. Words, you can write a word like advertising. Okay. The word like MTN. Those are abbreviations. MTN is already a trademark. It's registered. It's an abbreviation. Also, the yellow, their yellow mark and their blue, all that color formulation, it all comes out as a trademark. So for you people in this sector, maybe you've come up with trademarks. Every business ought to have a trademarks. You're quite fanciful people. You're quite creative people. You come up with things. Okay, you create things, and I suppose that all your businesses must be having trademarks. I can show you for one. You've seen in these slides, and you've seen URSB. URSB, that is our trademark. You will see URSB coming out in all the other in the slides I'm going to show you. Now, that is our trademark as URSB. That is what sells us out in the market. I'm dressed in a shirt. The shirt has URSB. If I hold an envelope, it has URSB. If I hold a pen, it has URSB. It means that I'm communicating and kind of I'm making the market deal with me because of my trademark, which has also become an important and big brand. And later I will talk about the difference between brand and a trademark. And I know you might also be interested in that kind of question. What is the difference then between a trademark and a brand? I will discuss it, I think, in the Q&A. But when you go out and society relates to you and society loves dealing with you, then you've created a brand upon yourself. So since you guys are in creatives, I know that you have different companies and different houses, and I suppose that those houses do have these appearances, trademarks, which you might need later to register for stronger protection. Okay, so that is the explanation. These are the trademarks that we have, and these are Ugandan trademarks. And maybe some of you have got involved in creating these, or making commercials for these people, or making, and somehow your sector has come to get involved with this outlook. Okay, so these are some of the brands, the trademarks that we have. These are the Ugandan service marks. You see banks. These are in the service sector. Mainly these were in the service sector for this slide, but they can also be products like Rwenzori ought to be here. Wava Water ought to be here. We can create what product? Mukwano products. Mukwano products is in food processing. They ought to be here as products, but these are service marks. Okay, and then we proceed, and then we have another type of IP, which is called patents. Patent, I'm going to explain it in detail. Patent means the title granted to protect an invention. So patents, the aspect of patent is that these are technologies. With a patent, you come up with something that is absolutely almost extremely new. This is seen in technologies, in product technologies. It's also seen in processes. Processes, that's when you come up with these patents. Patents is a bit highly technical, but I can give you an example. For instance, you see in food preservation in the food sector. You know now we take processed foods which are bottled, but you know that if for instance you cook beans, let's get an example. You make beans tonight, or maybe you made them tonight, and then you put them in a package, in a container, and then you expect to eat them the next day. Your beans at home, obviously you know what will happen. That one I don't need to explain. You obviously know that if you had packed to bring them to office to eat them, say at lunchtime, and then you pack them in a container, by 1 or 2, the time that you have your lunch, they will give you a false smell, so they have gone bad. And obviously you will not eat them and you will not share them with someone. But you know that somehow someone came up with preservatives. They came up with preservatives. They said, okay, if you are an eater of beans and maybe you enjoy eating beans and you enjoy packing beans from your home, you are going to pack beans, but there are also these preservatives. The preservatives, if you apply to your beans, then your beans will stay longer. That is what we call that. So someone came up with that technology of preserving foods. So if you come up with that technology of preserving foods, then that is your patent. You've come up with a patent because you've come up with something absolutely new that was never there in the beginning. So that is the idea about patents. Let's go on discussing them further. You will get to understand them, but just get a picture. So this is the newness I've been telling you. So most of us have this phone. You know this phone. Some of you have held this phone. Maybe some of our audience members are so young that for them, when they were born and they grew up, they went to this type. But for me, I'm in the generation that held this phone for a long time. So this phone was new because now it came from the desk phone that we're using. Again, that is also my generation, the desk phone. So it rang, and then you would pick up. So someone came up, said, but you know, I can make an invention where someone can walk with their own phone. So they come up with this mobile phone. So we came into the mobile phone age. And then the mobile phone transited so fast, so it became a smartphone. So now we're in the smartphone age. And so much intellectual property is coming on being created. All from the other aspect I told you that man creates. So there was a transition from here to here. So this becomes a patent, because if you compare these two gadgets, you'll see that this one on the right is very new and almost so different from, yes, they have the basis that they all communicate, but it's so different. You have a touch screen. You can do so many things. You can shop, you see Amazon there, you see eBay, you can see music is there, which this other phone on the left wasn't giving. So this person who came up with this created a patent. Okay, so we also have drug patents. You've had drug patents. You've had our societies competing with foreign societies in drug patents, especially during the HIV saga. So we are Africa, and we do not come up with these drugs, but our people were dying, and they wanted to access the drugs that were being made, the HIV drugs, because when you create a drug, it's considered to be technology. You've come up with something new, because now you've come up with a drug that can reduce someone's viral load inside. So that is technology that wasn't there. So now we're dealing with the epidemic of this SARS COVID-19. And you know the challenges that are there. Now it's an issue of patents. The vaccines are not coming in because someone invented some drug that can kind of counter this corona, and people are healthy. So the vaccines are there. You've seen them in the European Championships. They are there watching. And for us, Africa, here now we're experiencing a third wave, a so-called third wave, which is being very fatal. And somehow we are not getting access to these drugs because these are people's patents. We can't replicate them, and we have to buy them exorbitantly. Yeah, but that said, I think we also have this. So I included this slide here. I hope it can catch your attention. We have our COVIDX here. I just included this slide to show you that because I wanted to talk about drugs and patents. So we have COVIDX there. And COVIDX, we are just wondering whether it's a patent, it's working. Maybe this person can exploit it and take it further. But while these people are still playing politics and games and economics with their vaccines, we shall have COVIDX for in the meantime to take us around. It will remain whether this person can get some intellectual property out of COVIDX. Okay, we proceed. Then we have the designs. Designs are really just appearances. And I think this is also something that you can take interest in your sector. Designs are just appearances. The way a phone appears, for instance, you see you see phones advertising and they're showing slim, the slim phone, the slim phone that someone is selling, like the previous picture of the phone I was showing you. So these are just designs. The functionality stays the same, but the design is different. You know, for me, who is of the Nokia generation, the Nokia age, a time came when we said, you know what, this Nokia is just really making money off us. They just changed the housing. You know, that was the trick. You know, they just changed the housing. I mean, I held the 3310, and then someone held the N10 watt, and then someone held the 445 or something like that. But you see that all the functionality is the same. But you see, when they come up with a new design, people drop the phones that they have been having and they rush for the new design. That is the economics of design. So also designs are protected in intellectual property, that when you come up with a design, you can sell your product under that particular design. Okay, so we proceed, and that is the design. That is the most academic and the most durable design that we talk. Whenever we talk about this, we talk about this Coca-Cola, because Coca-Cola has spent billions of dollars, okay, maybe billions or up to millions, just to protect this design ever since it came up. So when you come up with a carbonated drink or any other drink, even mineral water, and then you design it and you come up with a bottle and design it this way, you would have been infringing on the intellectual property of Coca-Cola as far as designs are concerned. So Coca-Cola is what we call the locus classicus, the most fundamental aspect of discussing design. That is Coca-Cola, and that design is protected. Okay. So we have copyright now. Now, again, Kamara, we finished with that. That was to give you a background. Now we are going into the gist of where you guys come in. Where you guys really come in. Now we have copyright. We have copyright. All the other IPs we've talked about trademarks, which I want you to keep in mind because you might need them. You might need to use them. I've talked about patents, okay, which are high-end technology. They might not really be so much applicable to your industry, but I've also talked about designs, okay? Designs are quite important because you will come up with designs since you are creatives. Now we have copyright. Copyright now, that is the gist. I'm leading towards copyright. I need you to pay attention here because your sector really wholly, almost 95% concerns copyright as the legal protection. So copyright is an IP right pertaining to exclusive legal rights given to an author or an assignee. So when you come up with something in the creatives, then you're going to get copyright for it, for exactly what you do. The adverts that you've come up with, Bosco, the Bosco advert, There is also this other advert, one of my best adverts. I see the Spice Diana advert. I see the Bosco advert. I see there was an advert by MTN again, because I think MTN has made some of the best adverts in that level. The one of Rachel Magola, I think that was the 2000s advert. It was very good. It went viral. And there is also this other advert that attracted me of Sadolin, the colors. The colors, it was really very attractive, and actually that is the thing that also tuned me towards whether these adverts can be protected by the people who come up with them. It's the Sadolin advert, where the changing of colors, the zebras, I remember those billboards were all over town, saying that the zebras can have multiple colors. I think that was quite creative. So that is the sector, copyright. And copyright, when we talk about copyright, that means that the person who comes up with these adverts has authority over them, and they can determine how they can be used. And you can also bring an action, what we call an action, a court case against the person who uses your content without you authorizing them. Okay, so this is copyright. So these are images. We have images of these famous people. We have this is Samuel Eto'o. This is Toure. I think it's Yaya or Koro Toure. And then we have Mandela. Again, this one working for our age, because I think in today's football, the stars could be a bit different, but I wanted to pick out these African icons of sport and politics. So here, this is the image of copyright. So we have copyright. We have the images of these people. That's a different right. It's an image right when you use someone's image for your commercial benefit. But then we have the most important thing is there, the people who took these photographs. The people who took these photographs, these are the copyright owners of these photos, regardless of these photos are capturing people. So this is copyright, that is part of copyright, and also this is copyright. Okay, this is copyright. Now, the other aspect of copyright that is practical in our session that I'm going to tell you is the one where you record. Now, here we are having this webinar, this Zoom. This Zoom has been recorded. We are all aware that it's being recorded, and actually that's the reason why you found Zoom asking us whether we are ready to continue, because now we are agreeing that it should be recorded. So I'm here presenting, but for me, I'm a government officer, and you guys are also there. But the person who records this Zoom will then be the owner of the copyright. The copyright will go to you guys who have recorded this Zoom. And for me, who is just a presenter, I play a role, but I do not have ownership over the recording. So you can be free to give the recording to television. You can be free to give the recording as long as you are the owner. It's the aspect of ownership that is important. Okay. Then what do we do as an office? For us here, when you come to our floor at 6th floor, like you will do, I know that you will come. This is the brand that I was telling you. Our trademark is here. It's our copyright trademark is there. So this is our office. When you come to this floor, this is what we do. We receive applications. You apply to us and we receive your application. We also advise government on those issues I've talked about concerning IP. And then we also do what we call amendment of legislation that is really legalistic. These laws, these laws have to be changed. We are part of the advisors to government. We're actually the people who trigger off the amendment of these laws. And then we also issue certificates. So if you have property and you've come up with copyright, we shall give you a certificate of ownership. And then we also enforce that copyright. We enforce that copyright. How do we enforce that copyright? We enforce that copyright in a sense of, we have an IP enforcement unit, we have a police, but we also enforce copyright. So we can take a case to court, for you to bring an action to sue someone or to bring proceedings against someone who has infringed on your copyright. Okay, then we also carry out awareness programs like we are doing now, and then any other function which is assigned to us relating to IP. Okay, we also have records and statistics. So I'm here in this engagement, and this is one of the things that we do as an IP office, the one that is mandated to us under the law. Okay, and then we proceed. So this is where we are. So advertising agencies and IP. Okay, I hope you see this slide very well. Advertising agencies and IP. And this circle here, this is the global international recognized symbol for copyright. So if you've come up with a product that can be reduced to any kind of tangible form like this paper now I'm presenting to you, okay, you have to emboss it with this copyright, and you write the owner of the copyright, including the year when that work was made. Okay, so when any third party, if any third party sees this symbol of copyright, they are already informed that the work that they are dealing with is protected and belongs to someone. So they are not free to use that work as they wish. If they have to deal with that work, then they have to contact the copyright owner, the person who says that they are copyright owners, so that they can be able to use that work. They can be authorized, they can be allowed. Now, sorry. I still need to explain something here. Sorry, I still need to explain something here. You see here, I've showed you this, what you're looking at. So copyright Kalibala 2021. This means that this paper I'm presenting to you is owned by someone, and this is the person, and this is the year when that paper was made. This is today. So which means that no one is free to use my notes or my paper to present at university. I cannot find anyone analyzing my paper on television or making any comments over this paper without taking authorization from me. So this is the symbol. And if I find that person, I'm going to ask them why they did that when I already notified them that actually this paper is protected under the legal system of copyright. You also have to, sorry, yeah, that's what, but I just as a disclaimer, I brought this for just for the communication purposes, that this is the way it appears. For you people who are in the generation that used to buy music and tapes or CDs, you used to see that copyright was there, or when you buy a book, today it's in the books. Every book has that. In other words, it's informing you that you're not free to use that work unless you take permission from the author. But just as a disclaimer, this paper is not mine. This paper belongs to my employer, who is URSB. So, but this one, I just put it there for information purposes. So the paper, if you want to use this paper, and the only person who can stop you is URSB, not me, because this is in the line of my employment. So part of what I'm supposed to do is to develop papers. Okay, so now we go to what is advertising. Now here I might be a bit naive, and this is where you come in. I might be a bit naive because now I'm coming directly precisely to how copyright can help you, how intellectual property can help you in your sector. But this was general information to give me a background of what your sector is, so that I can have some background information. I can be informed while I discuss these issues of advertising. So advertising, what is advertising or advertising agencies? Is marketing communication that employs an openly sponsored non-personal message to sell a product, service, or idea. That is from Wikipedia. And then advertising is a means of communication with the user of a product or service. Advertisements are messages paid for by those who need them and intended to inform or influence people who receive them. Okay, that is as for the UK Association, Advertising Association of the UK. And then the advertising industry is the global industry of public relations and marketing. So in a nutshell, I can know what it is, me as a person. I can say advertising is this. I know what it means, it's marketing, but I wanted to get a precise definition of it. And that's why I told you it's important for you to know your trade. So this is the information I found out so that I can give you an informed discussion on this. That's my understanding of advertisement as per those sources. So what does advertising do? Well, what do you do as advertisers? Again, this is what I thought you do as people in this sector. First of all, you create content. And I want you to tell me, I want you to be comfortable that this is correct as I put it. You create content, and then you are commissioned to create content. Commissioned to create content means that someone has contracted you to create content. Okay, so you could be the creator of that content. Someone can contract you to create content. So you also have authors of content. Like I told you from the beginning of IP, that the content is created. The adverts I'm talking about, that Bosco and then that Sadolin adverts, they were created by people. That's authorship. You created that content, and then you sell content maybe to third parties. When they outsource you, you sell that content to them to use it, and then you employ celebrities to create this content, and then you employ actors to create this content. Okay. And then you have digital creators, the graphics people coming into computer. They are also there creating that content. And then you also have software developers probably also to create that content. These are all people. These are things that you do. And also there are people, there are things that also relate to ownership and protection. Okay. So what is, now I want you to relate that with what is protected under the law. This is what is created under the law. And this list, as you see, is not exclusive. We are not saying this is all that we create. This is a very broad aspect of creation. So, but what the law captured, I want you to read it and see whether there are things that actually you do precisely that were captured and envisaged by the law. We have articles, we have books, we have pamphlets, we have lectures, lectures, books, and pamphlets like the paper I'm presenting here. We have sermons from church, we have dramatic works, we have scripts, we have musical works, we have sound recordings, we have cinematographic works, we have choreography, we have works of drawing, painting, photography, architecture, sculpture, handicraft. These are broad items, but it's the list is non-exclusive. So you can read this broadly. For instance, article, what does it mean? Does it also include this? You can read them broadly. For instance, musical works. Are there musical works in your trade? So you can read it broadly. Are there cinematographic works in your trade? When I look at the Bosco advert, I can see that it's both a film and also it has musical, and it has actors. Okay, it was drama, it has a script behind it. That is the kind of thing. Okay. So what is not eligible for protection under copyright? You can take note this note of this. We shall discuss it. I think the Q&A will open us up more about what we can discuss. But now I want you to know what is not eligible for protection under copyright. So when you are in this position and you come up with these things and you say that like people usually come and say, someone used my idea. You know that if it's an idea, it is not protected. And that is a common thing that I hear so much in people in your trade. Ideas, concepts, I came up with my concept, I came up with my idea, and someone has taken it. Same thing as the president has said, same thing as Kamara said in our earlier discussion. You've used the words idea so much and concepts. And I want to tell you that ideas are not protected, concepts are not protected, procedures are not protected, methods are not protected, news of the day is not protected, and public benefit works are not protected. But I need to focus a little on these ideas and concepts, because those you will understand them better. Now, on the aspect of ideas and concepts, you see, an idea is what you have in your head. Okay, an idea is what you have in your head. It is not known by anyone. No one knows it. It's the same thing as concept. I think ideas and concept is how you make something, how you want to. So you in your head you have a structure of how you want to make something, and then an idea is the broadness of that. So when you have an idea, so you make a concept for those ideas. So as long as they are still mental and they are in your head, then they will not get any protection because they are not known by third parties. Here, the only remedy for this, and what I advise you to do, if you have an idea, reduce it into a concept and put the concept on paper. That is when your primary protection comes in. You have to put the concept on paper. And those concepts are what you have. So when you already put a concept on paper, you already have protection under copyright. That one we shall listen to it. So you will come with this book. You will come with this book and say, my Sadolin concept is here. I've written it here. Or you will say my Bosco concept is here. Or you will say my Rachel Magola concept, or like this lady, Diana, Spice Diana, who is now marketing that jacket product. You say that my concept is here, okay? And I've reduced it to writing, so I can read through it and I see. Now, the protection there that comes around is that your concept becomes an aspect of intellectual property. It becomes copyright. Your concept, when you reduce it into writing, you reduce it in material form, it becomes copyright. Now, the action that you can have is that if someone then uses that concept of yours, as you've been telling us, that someone then reads your concept and they take it, you can bring an action against that person if we really see that squarely, this person, as they came up with this concept, this person went ahead and then created dramatic works out of them. There you might have a case there. And that is what you have to protect. But if it's just an idea, you come and say, you tell you, I have an idea, there will be this guy who will come from the village, and then he will come riding a bicycle, blah, blah, and then we shall have a background song, and then maybe the man, we shall call him Bosco, and then we'll have a hat, that European hat, and then he will dress carelessly like a villager. And then that is the idea you have. And then you share that idea with someone, a friend of yours. That person is going to pick up that idea and reduce that idea into a concept very fast. So you will think that, then you will say, but you will come to us saying, but this was my idea, I gave it to this one. But you have no protection because it remained an idea while this person actually made it into writing. So you have to be very aware where your rights are, where the rights issue is. You're not going to bring anything against him if he got your idea and then you reduced your idea into a concept form, which is a book, and a book is protected under copyright. We shall discuss that further in the plenary, in the Q&A. So we proceed to works in the course of employment. Also, this I know that it affects you so much. The element of works in the course of employment. You people are advertisers, and this is what I came to know about your sector. You might make an advert that goes to Uganda breweries or Nile breweries, or you might make an advert that goes to MTN. The question that we're asking, is that actually your advert, or did these people employ you actually to make that advert? You have to separate those two things. Are you being outsourced so that you made an advert that you can use with MTN, you can take to Airtel, you can take to Legocom, you can take to Smile, or did MTN employ you in particular and they told you, you know what, this is what we are employing you. You are an advertising agency. Come up with this kind of advert, and then we are going to pay you for that. That is very critical. You have to understand that. So in the law and in the practice of copyright, where this is where you're not protected, this is where you do not have rights to that work, where a person creates a work in the course of employment by another person. So you are employed by another person to create that work, or on commission by another person or body. The commission is exactly the contract that you have with the person. So someone comes, Nile Breweries comes and tells you, we are contracting you to make this advert for us. That is a commission. Then in the absence of a contract, unless you have a contract that says that even if I make this advert, even if you've commissioned me to make this advert, I will remain the owner of that advert. But in case that contract is not there, then the copyright will vest in the employer of that advert, okay? The employing party will remain with the copyright. In other words, if Nile Breweries contracted you to make an advert for them, and you come up with this very beautiful advert of 1 minute, it goes viral, everyone wants it. So it has gone on social media, it has gone everywhere, everyone wants it. But remember that they contracted you to do that advert, which means that under all circumstances, they're going to remain the owner of that advert, and therefore you are excluded from stopping them to use it. They can use it however much they want. And I know that this is an issue in your trade. But on the other hand, there is another scenario. You could be outsourced. Someone can outsource you. And I do not know how this can be, how I can create a picture for this. Someone outsources you, so you come up with an advert that can be used by players in the same sector who do the same business. For instance, you come up with an advert that can be used by all the mobile phone companies. MTN can use it, Airtel can use it, Lico Mobile can use it, Smile can use it. So that is the advert that you've come up with. And under those circumstances, you retain the copyright. So you come into a deal with MTN to use that advert on your own terms. And it's non-exclusive. It's non-exclusive. So you tell MTN that after you use that advert, I also have a right to authorize Airtel to use this advert. I also have a right to authorize Lico Mobile to use this advert. So those are the two things. Either you are the creator of the content, or you are employed, you are commissioned to create that content. That is an issue of ownership. We shall discuss it. So rights under copyright. So when you create this content, what power do you have when you create? Let's imagine that you are the content creator. You are the owner of the advert. It's yours. It's not there. You have not been employed. What are your rights? Remember, I've written here what you see, that copyright is a private right and all protection and use is up to you, the owner. This property is yours. I can never know that your property is being infringed unless you bring it to my attention. So you have these rights. You have the right to protect the work. The work is yours. You have the right to publish. You have the right to produce and reproduce. You have the right to distribute or make available. You have the right to perform the work. You have the right to broadcast the work. You have the right to communicate the work. And you have the right to commercially rent the work. Now, what you see here, like I told you in the beginning, that we have a legal framework and a policy framework that is tilting towards entertainment, which is music and films. So when you see these rights, the people who made them, they were leaning mainly towards those aspects of copyright. And that's why I told you from the beginning that if we get to know your trade, we can know how you can have rights under that system, not necessarily based on this, but based on your own practice. What is your trade? What are your rights there? Do you have the right to ownership? When you go into contracts with third parties, are you licensing them to use, or you give them the whole product to use? And in which case you will have no claim on that product. So these are some of the rights. So how is copyright infringed? So you are now there, and you people have come to us and are telling us that your works are being infringed. You are not getting a fair deal. You are not getting a fair remuneration in your works. What is exactly, how are your works being infringed? How is your copyright being infringed? Okay, first of all, the first and primary element about copyright infringement, it occurs when any of the rights of the copyright owner or related rights owner are violated. In the earlier slide, when you're the owner of copyright and someone gets to use that content without your authorization, so they have violated your copyright. Okay, someone can use works without your authorization in case of no remuneration. In other words, you've gone into a business with someone, say like a big client like Nile Breweries, but they have not paid you. They have not paid you. So if they have not paid you and they go ahead to use your works, there is an element of infringement because the deal is not concluded. Then Use of works excessively, contrary to contract stipulation. So sometimes you might make, here I wanted to bring out the case like the element of Spice Diana with her advert for the Yaket water product. So these guys are making money out of her image, yeah? Because right now her image has almost become the name of the name of the product. You know, in the lower market, someone just say, oh, do you want Spice Diana or you want Renzori? You know, Spice Diana, go and get me Spice Diana. Spice Diana, the water has become the name of the celebrity on it. Yet the water has its own name. It's called Yaket. But you can see that the celebrity's name is bigger than the name of the water. So, but these people are churning out bottles upon bottles, bottles upon bottles, bottles upon bottles of water. So the thing is that, is there an infringement of copyright to both the person who, the people who are beyond that advert, the person who took that picture, and the celebrity? Because all these bottles that they are churning out, are they actually giving the people concerned about? So there could be an issue of infringement under those circumstances. And then use of works outside the contract. So you've come up with a contract, but someone has violated it. That is also an aspect. So use of the works by a party who is not authorized. So you've made a contract and you went into a contract to make an advert with MTN, but then you find that Airtel has used that advert. So there is an issue of copyright infringement. Okay, so this should be the last slide upon this, and this I'm going to emphasize this, sorry. I'm going to emphasize this is the second last slide, and then we'll go into the preliminaries. So protection and management. How do you protect your IP? How do you protect your copyright? If, for instance, now for all the things I've told you, so you are the copyright owner, you are the advertising agency, and as I've explained to you, you've come to a decision and a conclusion that actually this is your copyright. Okay, this is your copyright. How do you manage copyright? How do you manage it so that the exploitation of that work can be regulated by you? Okay, you can determine how it should be regulated, you can determine how it should be used, you can determine who uses it. How do you go into managing it? These are some of the aspects that I identified, especially coming from your practice itself. These are some of the aspects I had. For instance, there is need for you to understand your sector and its different contributors to content. Who are the people in your sector? Who are the contributors to content? Who contributed to content? When I look at the outlook of the Bosco advert, who are the people who actually contributed to that product so that it comes out the way it is? Those people have to be accounted for, and they have to be listed down. Because when an issue of copyright comes about, you'll be surprised. Even a person who told you that, no, he should not wear blue, let him wear green. That person might come out saying, but this work is mine because I also contributed to how the actor should be dressed like. Huh? Okay, so you have to know, you have to account for each and every person who has contributed to a product and their role, what they have contributed. That is what will constitute protection, and that's what will constitute a defense when you come to bring an action against infringers. All people are claiming. Now you have claims. The person can say, but MTN was supposed to pay me because I made this contribution. And then you also, but you know, you didn't make that, your contribution was not vital because we just told you to make the contribution. So whom is MTN paying? Who is now Breweries paying? And that is what I'm telling you, account for every person and their contribution to, and articulate their role, articulate their roles in coming up with the products. Then identify roles that relate to ownership, authorship, performance, commission, line of employment. These are the roles. Who is the owner? Whom do you say is the owner of the content? Remember that in copyright, I'm going to tell you something technical. In copyright, there has to be an owner. I'm giving you this presentation. So I've told you that the paper belongs to my employer, who is URSB. But remember that I'm the one who is presenting this paper. So in that aspect, I also have some rights as a presenter, and you might use my voice to go and do other things. So I have a right as a presenter, but it does not stop that the owner of the paper is URSB. So any product, any content that comes up, there has to be an owner. So when you create content, determine who is the owner of that. And the owner could be the person who creates it, or the person who authorizes it to be created. That could be the owner. And then we have the performer, like in that Bosco advert or the Rachel Magola advert, those people who are performing are there. And then we have commission. Commission is, are you being employed to do this, or are you being outsourced to do this and someone is contracting you, or you are the one who has created it and you want to vend it out. You want to vend it to third parties. Okay, then the line of employment. Then come up with contracts that relate to ownership. And in case of continuous monetary benefit, how much is shared. Please, colleagues, I want you to get used to this thing: contracts, contracts, and contracts. Come up with contracts. And a contract does not have to be detailed or legalistic. A contract is the document that shows that there is a relationship between these parties, and these are the terms of that relationship. I'm telling you, intellectual property and products are so big. We make contracts for land. Someone buys a spoon of land, just a spoon, just a small inch of land, and they already have contracts with it on it. But you come up with a product, you made an advert which has gone viral, and now there are issues of money, and third parties who want to help you cannot even know what was the basis of this relationship. They ask you, what is the contract? What were the terms of that contract? What did you agree in that contract? What did you say? How did you determine the usage? Where did you say it should be used? Okay, contracts. A contract can be 1 page, it can be 2 pages. You can leave it at 2 pages. It does not have to have complicated English. Even you yourself, ordinarily, you can come up with what you might call a contract, as long as the other person acknowledges and signs. Because when there is a dispute to copyright, when there is a dispute occurs, the third party is going to say, what was your understanding before this product was made? What was the basis of your contract, so that we can know that there was a violation? So please, in your practice and trade, come up with contracts. Contracts are necessary. They are just a bottom line. Then, to determine whether you are being contracted, outsourced, like I've explained, are you vending, or you've been outsourced? Okay, if you are the vendor of works to be used by a third party, you might determine where. So if you're just a vendor, you can go into a contract with a third party and determine how the works should be used. Okay, or if you're not a vendor and they have just contracted you, the person who contracts you will determine how the works are used. Then, in case of a dispute, arises, courts and tribunals are available to determine the issues, but need to be helped with the character of your sector. Yes, the third parties are there. We are there also as URSB. The tribunals are there, and the courts are there. But they have to determine if I can only get a write-up of the nature of your trade, how do you trade, where are the rights in your trade, who owns what, how do you come up with content, I can help you feed you exactly into the line of legal protection, which is copyright. So it's important for you to know your trade, so that third parties can come up, can be in a position to help you. And also these other determinations, like I've said, who are the owners, what are the rights under your rate. When you come up with a product, who are the people who actually own this? Where is the element of copyright? Okay, so Kamara, are we good? Are we good? Do I get a thumbs up? Because like I've told you, that is my last slide. So again, this is who we are, URSB, on the 6th floor. At the 6th floor, you can come. Like I promise you, I cannot say everything in this one. My time has run out. But if you've got the gist, we can go into the plenary in the Q&A. And then later on, when we are fully open, right now we're on rotation. As you've seen, I'm almost the only person in office. But when you're fully open, or you can, Liz has my telephone number. We can have side chats, and then we can also, you can also use email. You can contact us in any way. I've told you, we're the Copyright Information Center. Just like you called us to give you this discussion, we are under obligation. We owe this information to you. So when you have challenges in ownership, we are just open. That is my job. That's what I do. Okay. So thank you so much, colleagues. That's it.
Wow, thank you very much. As a result of the lockdown, there's work happening behind me, so I'm going to Liz, please take over for now.
Okay, thank you so much, Philip. I think this was a very insightful presentation that you made. I would like to open it up to the members. In case you have any questions, please raise a hand so that we'll be able to catch you, and then Philip will answer any questions that you might have. Anyone, any questions? Should I take it everyone is okay? No questions at all?
There's a hand up.
Where? I don't see any hand. Oh, yes, Rinaldi. Please feel free to also show us yourself. We have not seen you in a long time, so if you can open your camera. Don't be shy.
Apologies, I'm unable to, but my picture does great justice. It's not very old. It's a few months old. I hope you're all well. Thank you very, very much for this very, very great, what should I call it, presentation. I think it has been very eye-opening, and do appreciate UAF for the initiative, and of course, Mr. Kalibala, thank you. I think you've explained quite well. I have about 3-4 questions. I'll try to ask all of them at a go, and then maybe you can respond as others probably come up with theirs. So you gave us an example on copyright in relation to photography, where someone takes a picture, and in this case, you gave us Yaya Toure and the others, and you said, as the photographer, I own the content basically. So what happens for me whose picture is taken, and probably I didn't necessarily give consent to that person to take my picture? In this case, if I was Nelson Mandela, and some other person is able to take credit for the picture they took of me that I probably didn't necessarily give them consent for, how do I benefit from that as the person in that picture? You talked about just adding the copyright, which is the C with the the brackets that now forms a circle after you're done with that, and placing it into your works. Now, does that copyright apply without you necessarily registering it directly, or must you first register it? I think that's the question I have on that. So must I first register, or anytime I place it on my works, it's automatic that it shall actually be protected by the law? Next question. When you say, let us make sure our works are on paper, what does this mean? Today, I cannot deliver any works necessarily easily, physically, to any office, and yet I might develop some concepts, I might develop, these ideas as we called them, and actually have them in PowerPoint, in PDF, in MS Word, or any other format that is actually electronic. It could be email. So where's the place for e-copies of these works that might not necessarily be paper as we called it? Maybe I might have missed that, but at least I didn't hear any reference specifically to the electronic formats of these works. Yes, well, you talked about where we must put this on paper, yes, but in the event that there are actual witnesses to these ideas that were shared, yes, you did give a detailed explanation, but if there are people who were in that conversation where the ideas were being shared, and they can actually attest to the fact that indeed those ideas originated from you, does that apply, or is it still void? Thank you very much. Those were my questions. Over to you, Liz.
Okay, Philip, I think you can answer that because there are a set of 3 questions already, and then we'll move over to Peter's. I see Peter raised a hand.
All right, thank you, Liz. And in fact, I'm so happy. These are quite intelligent questions, very intelligent. They should themselves make their own independent discussion, but let me respond to them. The first question was in relation to photography, okay? So the issue of photography is a bit technical and a bit wide. That's why I didn't like to go into the detail of it, because I also do not want to give you a presentation that might leave you confused. I do not intend to give you an academic presentation. I intend to engage you in a way that you can use knowledge to better yourselves. That's why some of the things I had left them out, and I didn't go in detail of them, because I think I identified things that might be very primarily useful. Now, on the issue of images, it's true, because since you are in advertising, it is possible that there is so much photography and there is so much imagery there being taken. There are 2 things. These are people I've showed you, the icons. Those are global celebrities known everywhere. They are about 2 things. First of all, if a person like me, if I'm known and I've put myself in an environment where my picture has to be taken, then my picture will be taken. You cannot stop anyone from taking my picture. Right now I'm on Zoom, a screenshot is going to be made, so I'll be there. And rightly, I was in a meeting where a picture should be taken. So pictures of people, President Museveni, the Pope, Nelson Mandela, these people, the celebrities, when you've gone to a football game, you have a right to take pictures of those people, because that is, you found them in a place where you actually have to take pictures of them. It's expected that you should take pictures of them. So those are there. Then you've gone, maybe you are at a procession and then the Pope passed by, and then you take pictures of the Pope. That is true. These pictures that you see could be a bit deliberate, the ones of these icons. So those people might have been contracted to take those pictures. But the catch issue is here, how you use those pictures. So you've taken the picture of the Pope, but you've seen that sometimes these people have been selling umbrellas and caps and putting the Pope there. So we have Kolo Toure and we have Eto'o. There is a legal regime of protection which is called image rights. Image rights protecting everything about you, protecting your appearance, the way you walk, the way you dress, the way you speak, the way you laugh. Even the cartoons that come of you, even any impressions of you are protected under image rights. That's a different aspect of law. But for you to successfully sustain an aspect of image rights, for you to say that, okay, this is my image right, like Eto'o is, you have to be at that level of fame, like you are known, okay? Like you are known, so your image, you are known, so your image is protected, because also the person who is using it, probably they are making money off it. So I've shown you Chameleon's image. I cannot start using Chameleon's image whether to sell my calendars or to sell my cups, because one, Chameleon is famous, and I'm also benefiting from that sale commercially. So that is where the catch is. But I can take Chameleon's pictures everywhere and I just pin them in my house. I can make an album of those pictures. There is really nothing legally wrong with that, but the element is in use. You can also take a picture of me. For instance, you can take a picture of me and put it in the newspaper, but I'm also protected if you, for instance, if I become an instant celebrity. You know, these people who become instant celebrities, like this lady of Process by Process. That is a good picture. She's now there and she's now a celebrity, you know, her picture and her words and everything. And she didn't know that she was coming into the limelight of, you know, the celebrity dome. She didn't know that she was, but now she's a celebrity. She's all over social media, her images and then her words and then her voices. So in case I get those and then I try to exploit them commercially, she might have a case in image rights. So it's about balancing it. Yes, I've taken a picture of a celebrity where I was supposed to take it, but what have I used it for? That is where the legal system comes in to protect that person, because you're not supposed to benefit commercially from the image of another person. So you have to, in other words, how does it work? You have to come into an understanding. I'm going to take your picture. You are a celebrity, and these are the terms, and this is the way you're going to be paid. Let's just make a business and a deal. So you do not have the right to just use it without taking leave. Okay, and then the other thing, adding copyright, which is, this is also an important thing. You add copyright, you add this. So is there a necessity for you to actually formalize in protection? Now, the way copyright works is that you do not have to protect, by the way. That is just what it is. It's interpreted, you do not have to protect. Because copyright is so frequent. For instance, all of you come from advertising houses. Huh? Maybe 1,000 adverts can come up in a week. Audio, visual, what, pictorial, and all that. And the whole system cannot really come up to say that it's going to be able to protect you at once. So what happens is that the protection was left to you. There are also the other reason why the protection was left to you is, like I've explained to you, I think I've explained it, I've mentioned it. Copyright, so many, all of us here, as you see, we are so far 20 here, can be involved in making a work. All of us can be involved in making a work. And the issues might be actually who is the owner of these works. All of us can have our own claims. This one claims that, this one claims that, the other one claims that, this one claims that. So it becomes very hard for you to just come and say and protect. First of all, for us to protect all the songs and everything that is there becomes cumbersome, but also the issue of ownership. So that is why we left the ownership to you. And then as long as you put this emblem of C, you are already notifying third parties. Third parties are on notice, as we say in law. If someone uses that work, if you put this C there, and someone comes and uses that work without my authorization, okay, without my authorization, then there is an issue. And we are going to ask them, didn't you see the C? Didn't you know what it means? You see, we buy these phones all the time. And when you open up these phones, there is so much literature now, it's on soft copy, the literature is there, but you will see the C there that this manual is owned by this is owned by this, the C's are, but they are notifying you. So you do not have the freedom to go and use that information elsewhere without asking them for permission. That is just for you to know you've been notified. So if anything, if someone takes you to court, or if police comes to arrest you, you're already notified by that, so that this content has belonging. Then we have, let us, our works. Okay, reduction into material form. Like I told you that copyright does not protect concepts or ideas, because we imagine that concepts and ideas are still in your head. Whether you had witnesses, whether we are here, for instance, I could be here and I come up with an idea that let's come up with a hologram. Hologram. But even here, I've reduced it into material form because now it's going to go into recording. But imagine that there are no gadgets of recording. So we are there and we say, oh, we have an idea. I'm going to come up with a hologram that is like a patent. It's a new thing. And the hologram of someone who has passed on is going to be used for advertisements. Okay. So we are there in a mango tree and no recording, no phone. Then maybe Liz or Kamara goes and gets that and says, okay, I heard Kalibala talking about a hologram. Let me reduce it into writing. So you make a record of it and you make a concept of it, or you write it down, or by soft copy or email. You've already reduced it into writing. So that is what we mean by reduction into writing, that it's already reduced in material form, and there we can start protecting. But as long as it's still in your head, no one knows it, then someone comes up with it, then you are there and say, but this was my idea. The issue is that we're going to ask you, where did you reduce it into writing? So at Rinaldi, all these other soft copy aspects, you put it in soft copy, you put it in writing, you put it on a flash, you put it in a song, you put it in wording, all that accounts for reduction into material form. It's already reduced into material form. It comes from your head and then it goes there. Then there is, yes, of course, I've also answered that even witnesses cannot save you. If we are 20 people here and then an idea came up and then we are all there witnessing, say, but no, we were there. The idea, that was this idea, this man just told it. Even that doesn't suffice. What is most important is that when you have that idea, please reduce it into writing by making a concept of it. Just making a concept, even if you write it in pencil here, in pen, as long as it can be easily identified that it was the concept, that is the concept of what it was. For us in a legal system, under the legal framework, we shall just take it on and then say that this man already had this concept. You've infringed on his script or his concept or his literary work. Because when you reduce it into writing, it becomes protected under copyright. Thank you.
Over to you, Peter. You have your hand raised.
All right. Thank you, Liz. Thank you, Philip. I have 3 questions. I'll start with the third because I think that's where Philip ended last. It's very related. So my third question says, how do you prove that you came up with the concept first? Because Philip, you have clearly mentioned that you need to have it written and then you have proof that, yes, I had it written and then this person came and infringed on it. So my question is, how do you prove that you came with it first? Is it by way of dates? Is it by, what are some of the means or criteria that you can use to prove that you came up with this concept first? And then also, when do you report or bring the concept, when do you report or bring the concept for the IPs being infringed on? At what point do you report? Do you report at when you sit up there with somebody and then you come back with your evidence, that the evidence that you're probably going to explain in my earlier question? Then the other question is IP authorization written or verbal? Can it be just verbal or it must be written? And then if it's written, does it have to be paid or it can just be out of goodwill? Say, for example, I've come up with an idea and then maybe somebody, or it could be even an image or anything, and somebody wants to use it. Do they have to pay for it or can it be just a mutual agreement of, okay, I allow you to use my property? And then the third question, what is the procedure for reporting IP or copyright infringement? And then how long does it take? And then what are some of the repercussions? Do they make the person pay? Do they have to pull down that communication? Say, for example, if it was a concept that they took from me. Yeah, those are my 3 questions. I hope they're very clear. Thank you.
Thank you, Peter. Questions are very clear and extremely pertinent, as we say in my trade, that they are pertinent questions, very important and very relevant. Now, and I'm going to approach them this way. How do you prove that you came up with a concept? And like you've used the word, it's an issue of proof. that is very technical, even, and that actually requires a third party when you go to a tribunal. And those are the issues that are left with the court. That is an evidential, it's an evidential issue. It's an issue of evidence. How do we prove that I came up with a concept earlier than you? Okay, it will be an issue of proof. Now it's like I'm imagining there is a dispute and you are before a third party. Like in my trade, in my legal trade, I will have to ask you questions to prove that. Just like I have to ask the other person questions to prove that. And then the judge, the person who is the third party who is judging, will determine that actually this person came up with this product first. But what you can do to help yourself, it's like the issue of reduction into writing, reduce something to material form. That is quite important. It can give you, and that is the reason why I've showed you that when you put the C, you also have to put the year of publication. Usually it's the year, but you can also put the date. Now, the year of publication means when did you put it on the market? When did the world come to know about that product? Like for me, my paper, it is 2021. So now I've presented it before you. It has been published that year. So maybe tomorrow or the other day, and also all this session is in recording. That is part of my evidence. Maybe tomorrow or the other day, someone might change the naming and who is the copyright owner, and they present that maybe at a university or somewhere, or they use it for their research or something, and they have not given me credit or paid me for it. And they might also claim that they are the owners. So these are some of the things that are going to be looked at. That when did you present, you Kalibala, you say, when did you present this? At what forum did you present it? When were they? So those things will come up. And at the same time, this other second claimant is also going to be as so. That is an issue of proof. Even you yourself in your practice, you will not come to a conclusion with that. So you come up, Peter, you come up with a concept, you write, you reduce it into writing. Also, Liz comes up with a concept. Okay, the identical concept. And now the issue is who actually came up with this first. That is an issue of evidence. It's an issue of an adjudicating system. Okay, yeah, so that is where it will be resolved. So that one, don't worry so much about it. When the issue comes, when the dispute comes, then you go to a third party and you make your case. But you can also use registration, like we've said. I think that is one of the fastest. Okay, the principle, the whole principle of copyright is that registration is not necessary, because I've told you the frequency of its creation, and then the confusion of who owns. But in case you feel like you should register, you can come and register it in time. You can say that, okay, when I created it, I also went to the IP office. Because registration is open. You guys, when you come up with your concepts and they're actually yours, or you come up with your products adverts and they're actually yours, you can come and register them. We shall register them. That will be part of your evidence that actually you are the first person who came up with this and it's yours. Then where do you report violation? First of all, there are two issues. Violations, again, I'm going to approach it legally. First of all, I've told you that copyright is a private right. It is yours. And for us as third parties, we can never know that there was a violation unless you bring that to our attention, unless you come and report to us that actually, you know what, Philip, as you are there, this company or these people have used my property without my permission. Unless you bring it to our attention, we can never know. So it's a private right and it's yours. So when that happens, these are the things that you might do. Court is open to you. You might go to court. And again, that combining it with one of the last questions that you asked, you might go to court to ask for remedies, equitable remuneration for the use of your works or anything like that. For the use of your works, you want to be remedied, you want to be given, or you might go the criminal way. The criminal way is when you bring prosecution against that person. So what you do is that if someone has violated your copyright, you go to the police, you go to our police, and we have an enforcement police here, and then you report, because the subject is technical, but these people are well versed because we've taken them through all these systems. So you go and you report to the police, and then police goes and arrests that person or those infringing persons, and then they bring them to court for prosecution. Now that might work in trademarks, and it might also work in trademarks and copyright, because we've used that system so well and it has worked. But the thing is that the thing about copyright is in your trade here is that, for instance, if Nile Breweries gets your advert, I can give you an example. Katatumba. The case was Angela Katatumba and the environmental body that she was making sound for. So there was an action of them of infringement of copyright because they used her content, which was her song, without her authorization. Maybe the contract had already ended, maybe something, but she came and brought an action against them as the copyright owner. In that case, these people have already used your content. So the only remedy there is for you to pay, them to pay you. You have to quantify the violation. You have to say that, okay, my content, you used it for 2 weeks, and in 2 weeks I would have paid this and this. The lawyers will help you come up with that. So you come up with a list of damages that I quantify in terms of money. This is how much I've lost, and they will have to pay you. Because with copyright, except with very few exceptions, it is very hard for us to reverse what has already been done. All right. So maybe a big client has used your works without your permission. They have already used them. They're already in the public domain, and they have also created an element on them. So they're already there. But so that is very hard to reduce, to reverse. So now the issue is that we are saying that the person whose rights have been violated, how are they going to be held? And usually that's where the money element comes in, that they pay you money to compensate you for the use of that work. It's usually monetary remedies. You might not stop them from the use, but they will compensate you. And then is IP authorization verbal or written? Well, the best practice here would be that write everything. And the IP laws require contracts. Copyright requires contracts. Write everything, put everything in writing. Do not verbalize things. Verbal things, that is an old practice. Right now we are in the writing age. You can write something. That's what I would advise you under practice. I do not know of a situation in your practice where you might say, in your trade, where you might say, I've given you verbal authorization, you can't use mine. So it might be hard for you to claim rights under that kind of arrangement. But please get used to writing. That is the first. They might be verbal, and when they are verbal and a dispute comes, then you will have to go to court to determine whether actually the authorization was verbal or not. But writing is the best practice, really. That is what is for everyone. Learn to write documents in as far as rights are concerned, in as far as authorization is concerned. Then what is the procedure? There is something to do with the procedure for IP. So if someone infringes your IP, how do you go about it? The courts are available, but also our criminal system is available. But in your trade and in your practice, I think it will be there will be civil suits under this, that you're going to sue someone for infringement of your copyright so that these people can compensate you. Because in criminal proceedings, you get no compensation. You get no compensation. The person is prosecuted and sentenced to some fines or to jail, and they will be there for 2 years, but you will get nothing. The criminal system is very punitive, and you as the infringed person, you benefit from, you don't benefit commercially. You cannot benefit, but in the civil system, someone can pay you even up to 200 million shillings just for infringement of your copyright, if they actually used it and benefited from it. Thank you.
Okay, thank you, Philip. We have a couple of more questions here in the chat. One from Ariho is URSB interlinked with other bodies of its kind worldwide? What happens when a multinational takes an idea from Uganda, or even images of a photo shoot done in Uganda, into another territory? Are they infringing on my rights if the contract is silent about using the images in different territories? Let's take that and then we'll ask the next question.
Thank you so much, Kamara. That is also a very good question, very intelligent. Now, but that question would be appropriately responded to if we are talking about music and cinematographic works. Like I've told you, since this is a new field and we want to know your trade, how you go about your trade. I might not give you an answer that might help you appropriately, but I'm going to give you information of how that works. Now, if your works are going to be used in the international market, it is presumed ideally limited Kenya. Let me use Kenya as a next neighbor. Kenya is a good example, because sometimes even our companies are multinationals working in both countries. So you've made maybe an advert for MTN, and then maybe Safaricom adopts it. And Safaricom might take on that advert knowing the rules that govern intellectual property, very much knowing them. And that is very important. They know the rules. They know that we are using works that are not ours. But the question is that how do they pay? They are looking for a system of how they can pay the copyright owner. Now, in the practice of music and films, we have what we call collective management organizations. They are called CMO in short, CMOs. They are collective management organizations. Those organizations are quite international. They are international. So you might find a CMO in Uganda, and we have them, and also a CMO in Kenya. So what happens is that if you are a member of that CMO and you see that your works are being used, you only have to talk to your CMO And then your CMO will talk to the Kenyan CMO and tell the Kenyan CMO that, you know what, our members' works are being used in your market. We want you to follow those people and you get reparations from them so that the money can be given to our member here in Uganda. You understand? That is the CMO. Now, for you advertisers, if, for instance, even you yourselves, you can create a CMO. It depends on if this trade goes on and that becomes a common thing that people are using your works elsewhere. You yourselves, we shall create a CMO for you, particularly to enforce the your own economic rights. We are going to create a CMO for you. So you will say that I found that my idea or my advert is being used in Zimbabwe. So you'll be able to call the representative in Zimbabwe. Your CMO here, what we call your CMO here, will be in a position to call the CMO in Zimbabwe and tell them, you know what, our members' works are being used. That is the way it works. Otherwise, you as a person, you might not be very much in a position, say, to go to Zimbabwe or to go to Tanzania or to go to Kenya, because you have to go there physically, and then you have to make a claim there, and then they will have to subject you to their own laws. Okay, their own laws of whether they should pay you or not. It might be cumbersome for an individual, but the only remedy for that, it works through a CMO system, which of course you advertisers, you don't yet have, but it is there in music. It is there in music, in films, and in books. Thank you.
Okay, thank you, Philip. The next question is from Janet, and she's asking, hi, Philip, in the case of images, what happens if a celebrity's image is used to represent a brand they work for or whose work they represent? For example, if I use an image of Chameleon and other musicians as a representation of, let's say, Leon Island on a concert poster, a concert they are going to be part of, do I still have to get their permission?
Thank you for that question. The bottom line is, as long as something is protected under intellectual property, then any usage of it will be done with the permission of the person who owns. I've informed you about image rights. Image rights accrue to the types of these people. Chameleons is image. Even if Leon Island is this company and he has shares in it, he might not consent to you using his image for that particular action. So he himself can bring an action against his own company. So it's not something you take for granted. You have to ask permission anywhere where you're going to use someone's image. You have to ask for permission. The other way that you can use someone's image without someone's content, IP or otherwise, without taking the permission of this person, is what we call fair use. Fair use is very important. Also, fair use, I did not bring it to your attention because I don't know whether it's applicable in your trade. Fair use is where your image, your song, your copyright, your pictures, your what, anything to do with your intellectual property has been used under very minimal circumstances to promote something else, like to discuss something else, especially to discuss. Now, for instance, I can give you an example, the Bosco advert, the Bosco advert. So say in case we are discussing adverts on TV and they bring in clips of that advert, they bring in clips. That is what we call fair use. Like primarily, your works are not being used to benefit anything, but they are being used either for study, either to communicate something. Like you see, these movie programs, NBS has those movie programs. They have a program, so they can discuss movies that are in cinema, and then they start showing us clips. Okay, ordinarily that would be copyright infringement because did they ask for permission to use those clips? No, but that is allowed under the trade. It's allowed that, okay, if someone is going to analyze this program and it's a cinema program, they are allowed to use those clips. And in fact, those clips are supplied. They're already supplied beforehand, the ones that are used for marketing. So it's the same thing here that I can use. Now I've used Chameleon's image. I've also used Eto's image. I've used Mandela's image and I've used Touré's image, but they cannot bring an action against me because I'm using them for the purposes of making this presentation. The presentation is not commercial. I'm not a businessman selling my thesis or anything. So my defense is that I used it for under fair use, even if these images are used, and even if the photographer is the copyright owner, I'll still tell them that I use them under fair use. That is the only exception.
Okay, so Philip, someone sent me a direct message and was talking about pitching. So we do a lot of pitching as agencies, and during those pitch presentations, we present ideas and concepts. But out of the whole pitch lot, the company will probably pick maybe one agency and will not pick all the others. But of course, we've already presented to them our works, and some have even sent them on email and all. So if we find that the client uses our work without our permission, without taking on our services, do we have a case to present to the courts of law?
Can I just briefly tell me exactly what pitching is in the practical sense? What do you do, or what is pitching?
Okay, so let's say URSB calls for advertising agencies to bid for advertising work. Let's out of UAA's membership, we have about 13 members. So let's say all our 13 members submit their proposals, and then they even go ahead to present to them in physical meetings or whatever. And they also send them the work on email, you know. So some clients sometimes will not respond or will not give us any feedback, but then you find that they are probably putting out work that is similar to something that you've presented to them. Or they'll take on another agency to execute ideas that have been presented to them during the proposal period. So do we have a case?
Now that question is very good, because it's primarily and it's very precise about your trade. That is very important. It's a very good question. And I'm going to advise you to do it like this in a practical sense. If it's an element of what you call pitching, so you come before a third party who is the client and you try to impress them with your ideas and your things that you've come up with. I want you to remember one thing. I do not know whether you know what in Casio rooms. I followed up on that, and sometimes I get interested in it. In Casio rooms, of course, which we don't have here. So when a Casio room is there, a showroom, you get cars that manufacturers are putting on the market. New cars, whatnot, and this cars, that cars, they are there. The BMWs are there. They are put on the market and they are ready to sell. But they also have what they call the concept car platform, where they are putting up future cars. Say they are saying that the car of 2030 is going to look like this, and it's a flying car. Okay, or they say that the car of 2030 is going to be a talking car, or the car for 2050 will be a multi-purpose machine, which can be a car. It can also turn into a human being. It cannot. You see, that is an aspect of a concept. A concept is not something that is now being practiced, but it's something that people are hoping, are saying that will come in the future. But it is here. The idea is here. It's already in the making. We are going to make a flying car, but we are still going through other, maybe research, maybe doing what, or discussing with authorities and see if this car by 2030 will be a reality. That is what so now pitching, I've really understood it, that it can come in line of that. And I've explained to you from the beginning that even with pitching, please reduce that concept, the concept that you're going to produce, reduce it into material form. If it's a concept like you want to write, create a script for it. And I would advise you that if you intended that it is a video, for instance, if it is this advert of Sadolin and the zebra, the multicolored zebra, you actually come up with that. Let it be done, because when you come up with it, it's already yours. It is already yours. It is already yours. You can put it on CD. You can put it anywhere. You can say this is the paper for it. Don't just present it offhand like it is not anywhere in material form. We can't find it anywhere. Please make it yours. That is already your property. And you're telling them that if you buy into my idea, if you buy into my concept, then contract me, and that actually we shall make it into reality. Maybe you can direct me on how to change this and this, but the bottom line is that this is mine. Okay, you have to reduce it in video, in literary form, in sound recordings. It has to be there. And then it is the same thing, even if it's an audiovisual work, it's a cinematography work like the Bosco advert. Even let it already come. You might not use those characters. It might be something, maybe the characters were different, maybe, but let it be made into a tangible form, material form. Let it be actually a video, so that when you are presenting before the third parties, you can say this is the way it will come out. In that way, if someone steals it, you have a case, because we have a basis. You can say when we went for pitching, these people, I think they sidelined me. They did not take me on, but then they used their own internal people to come up with this. It came up. I wish I could have an example that I could show you over that, where someone actually exactly used someone's material to make their own advert. Okay, so even if it comes to pitching, please let this content be reduced into, let the content be reduced into material form, because otherwise, if it's not reduced into material form, then you're not going to say that I had an idea. Let it already be there. Like the concept aspect I've told you about cars, that the concept car, actually the concept car, if you go to a car showroom, the concept car is already there. It moves. Even if it's a flying car, it actually flies. It's already flying. They can test it, they are flying, but it's still prototype. It's still a prototype, and they have not yet deployed it in the market, so it's there. And they have already protected it with different patents. So if you come up with a flying car tomorrow, if you look at it and you go and reverse engineer and you go to your manufacturing company, because you already can make a flying car, and then you make that flying car, you already be infringing on the copyright of this person. So in a nutshell, when you go to pitch, when you're pitching, please already have the material reduced into some tangible form.
All right, thank you, Philip. I see we have one more question from Robert. Robert, please ask, and then we'll need to wrap this up as we are now time bound.
Okay. Thank you, Liz. Presentation has been very good. Just want to dwell a bit on that last question that you have raised. This thing, major pitches where we are asked to come with videos and whatever is a real concern in our industry. Okay, the last year and a half we've been under lockdown, so we haven't had a lot of that. But I can tell you, even me from my agency point of view, you have pitched for something and then you see a slightly modified version of it being carried out by another company. Yeah, so is there a way we can farm up a partnership with Uganda Registration Services Bureau? Because sometimes these time periods are very short. I think it will help now that you've understood our industry. Maybe if on your website you can say something about forgive me, about the advertising creative industry, because we are really victims of this con, if I may call it. And it's not just small players who do that. Big companies do that to all of us. As an advertising association, we've tried creating a code around it, but it's very difficult to enforce. So I think a good partnership with Uganda Registration Services Bureau will really help in addressing this. Thank you.
Thank you, Robert. By the way, it is not really very hard to enforce. It is just that we have to know your trade. This is a good forum, maybe the first of its kind. It's important that now I've never had a copyright or intellectual discussion with advertisers. I didn't even know that there was an institution concerning with advertisement, or people and advertisement have an association. I didn't know that you are that organized. I didn't know it was a big deal, though I know that it's a money-making sector, but I didn't know that you are this organized. Now, the most important thing is for you to market your trade, like I told you, to tell us what your trade is all about. Your trade is all about. Because like I can give you an example. Even music, we've had the same issue, even with film. So imagine that you see these radios that are playing music, they are infringing on copyright. The owners of the music really have not given them the permission to use, but there is a copyright infringement. So you also go downtown and you find that when Chameleon comes up with a song, you find these boys replicating in CDs. They have been infringing copyright. Okay, they have been infringing copyright because Chameleon has not given them permission to do that. But imagine that Chameleon now went to police and told them that, look here, my copyright has been infringed upon. It has been pirated. There are kids out there who are duplicating it, or there are radios that are playing it without my permission. Can you please come and arrest them? So in the beginning, we had challenges with this because a policeman is used to physical things. He's used, one, to stealing physical things. His mindset is about stealing physical things. His mindset is about arresting an individual. So now you are telling him music. Music is not land. Music is not a phone. Music is not a car. Music is not it's not anything that he has enforced on. He has not arrested anyone for music. He does not know what music is. How do we bring an action against a person because he's using someone else's music? Music is intangible. You cannot put music in the pocket. You cannot put music in a bag. You can't put it anywhere. It's just in the air. But it's property. So, but as we went on to know the trade and actually to know the trade and know the property nature, so now they appreciate. They know that immediately, because it's about music, is that as long as a party uses that music without getting authorization from the owner, that's already a crime. So now we know that. Anywhere you go to police, you say, my music has been infringed upon. They say, who has infringed it? It's this person. Let us go and arrest that person. So the thing about the thing about your trade is that we have to know now that pitching aspect. If I was to look at it strictly in a copyright sense, if I was to look at it without knowledge, without the knowledge of how your trade works, I might not even assist you necessarily, because there is something about copyright that I wanted to inform you about, actually, which can be a practice in your trade. Copyright is very much about expression. Expression. So you've had these love songs. Juliana Kanyomozi can sing a love song. Also, Irene Nambiru can sing a love song. Even the lyrics could be kind of the same. Even the tune could sound a bit similar. But these are very different songs from a copyright point of view. Juliana cannot go to court and say, you know what, I've discovered that 60% of my lyrics were used by Irene Nambiru. That is different. So it is the same thing. So when you go for pitching and then you present your concept, now it's even beyond the concept. It's no longer really a concept. It has come into, so you present a Bosco, Bosco kind of thing, the way it was. Bosco comes from the village, and then someone gets it and said, okay, instead of Bosco, we are going to use a high-end person, and then maybe we are going to use someone who speaks English, and then we are going to, someone has a change of that. It might be difficult for you to get a copyright action infringement if the other person expressed it differently. It becomes a bit different because someone is going to read your script and then your video and say, but this is what you had in mind, but this person has expressed it differently. That can be a bit controversial and you might not understand it necessarily. But the most important thing is that if you bring it to a person who understands the nature of your trade and a third party knows that, no, you know what, in pitching, actually creators bring their ideas, they bring their videos and everything, and then they are stolen by the third parties, and then they change just a little bit, a few things. Then someone can appreciate, you understand? Someone can appreciate and say, oh, so this is a practice in the trade. I'm going to be a bit lenient when I'm looking at this case. But if you bring it before a person, even if they're a copyright guru, but they do not know the practice of the trade, you might find hard, because like I've said, this person, okay, now this person had the zebra for the saddling colors. You know, that advert, it attracted me so much, the zebra. So imagine another person brought a giraffe. Okay, so imagine Jude Color Solution said, okay, instead of using during the pitching, this person brings a zebra and says zebra is multicolored, it's black and white, but now we're saying that saddling can actually give a zebra multicolors. Can give it green, can give it brown, it can give it yellow. Then another person says, okay, this person has brought a zebra, let me bring a giraffe. Let me also bring a multicolored giraffe. There could be a difference in those two works. Okay, so the pirate, the agency, the company that's stealing from you can steal your idea and change the animal. And they can change the animal. And then when they change the animal already, that could be different from what you've presented. So the expression is an issue. But like I've said, if you bring your trade to us and we get, especially now for us as the copyright office, you can be able to appreciate your trade and know that actually these things happen and these people deserve protection, which is bigger than the ordinary protection. Thank you.
Thank you very much, Philip. I think this has been a very insightful session for all of us. Just to read maybe some of the comments that have come through. Ariho says, in addition to Robert's submission, can we have a mechanism of registering ideas at creation and before pitch? Also through URSB, have the large businesses sign copyright protection agreements to stop this at the source. And then Peter says, thanks, Philip. I guess your explanation here explains Coca-Cola and Reham Cola scenario, the twist in expression. I want to take this opportunity to thank you, Philip, and then pass over the mic to our chairman, Frank, to close this session. Yes, over to you, Frank.
Oh, thank you very much, Liz. Thank you, Ario. Big thank you to Philip and the URSB fraternity. I think this session has been very, very insightful. Beyond IP, I got to know that you can also register your design. I was even texting my client. I'm like, yo, this design, we need to register it. Otherwise, you wake up one day and another brand has taken it. From a UA point of view, I feel we need to engage with URSB a little bit further so that you can understand our trade, and probably start tweaking some of the, so that we can have a policy that covers the advertising association. And maybe at some point even launch this and say, what, we engaged and now we have this. I hope there's that room, and immediately after this, in the subsequent weeks, months, we'll be in touch and see how we can do this. So I also want to thank everybody who spared like their 1 hour 30 minutes. I hope this conversation has been fruitful, has been beneficial, and from a Uganda Advertising Association point of view, we shall be having these webinars once every month. Thank you, and I wish you all a beautiful, beautiful day and the rest of your week. Bye-bye.